Um, Number one, in terms of introducing myself a bit, I use she, her pronouns. You'll see also that I have PWD, which is person with a disability, to indicate I'm a person with a non-manifest disability. I've been out as a lesbian. I was just figuring it out on my calculator for about 46 years and started my advocacy work in 1988 while working for the ACLU during the AIDS epidemic, working on the Americans with Disabilities Act. I spent about 18 years as a law professor at Georgetown Law School, where I worked as a consultant to various groups working on the Employment Non-Discrimination Act, legislation to prohibit discrimination against LGBT people. And then finally, when I went to the EOC in 2010, that's where during that decade, we were able to really make advances in protecting LGBTQ people. And that is what I will be talking about initially, and then how to vindicate those rights through the EEO process. Okay, state of the law for LGBTQ people today. So let's look at this first slide. Here's the bottom line. Employment discrimination on the basis of sexual orientation, gender identity is prohibited right now under federal law. It is prohibited right now under federal law if you're discriminated against for being LGBTQ. This applies to all federal employees and applicants. It also applies to everyone in the private sector working for an employer with 15 or more employees, although we're going to focus on federal employees today. This protection cannot be changed by an executive order from a president. You notice, and I will say for folks who cannot see, this thing is bolded, underlined, and the word cannot is all in capitals. So this protection exists. Okay, so now let's talk about how this federal protection for LGBTQ plus employees and applicants came about, right? Your tiny short history here is that when Title VII was passed in 1964 and said sex discrimination was prohibited, EOC got some complaints from trans folks and gay folks, and EOC said, oh, you're not covered under this law. And the courts just followed that for decades. And then that changed, and it changed because of two federal sector cases. One, Macy in 2012, where the EOC ruled that gender identity discrimination is a form of sex discrimination. Case of Baldwin in 2015 said sexual orientation discrimination was a form of sex discrimination. And then in a case called Lusardi, specifically, EOC ruled that trans employees have to be permitted to use the bathroom consistent with their gender identity, and that intentional misgendering is harassment. This is all the law still for EEOC. And now we're gonna go next. So what happened next? The legal landscape changed because of those decisions that EOC issued in 2012 and 2015. So in 2018, all these courts that had never covered gay folks, trans folks, 2018, you get one circuit that says, oh, we're changing our position. It's a prohibited form of sex discrimination to discriminate based on sexual orientation. Another circuit court says that. And then in 2020, the Supreme Court takes the issue and rules sexual orientation discrimination, gender identity discrimination are both prohibited forms of sex discrimination. This Supreme Court decision cannot be undone by an executive order by one president. Okay, that's the law. So now you're a federal employee, also applicants for federal jobs, but assume federal employees. How do you actually file a complaint? So here are various steps. Now you will see a pattern in these steps. You will see that some things are better for federal employees or applicants for federal jobs, and some things are worse than if you were just in the private sector and not a federal employee. Okay, what's worse is some of the short timeframes. What's better is if you win at the EOC, you don't have to go to court. Okay, step number one. If you experience discrimination in your federal agency, you must contact an EEO counselor in your agency within 45 calendar days of experiencing discrimination. If you leave this webinar with nothing else, it is that you know, and you can tell friends who need to know, you have to contact the counselor within 45 calendar days of experiencing the discrimination. You don't have to have a whole complaint, written up. You just need to contact that EEO counselor. Okay. Second, once you contact the counselor will call you, you set up a session. The counselor is going to give you a choice to participate either in what's called EEO counseling or in alternative dispute resolution. Here's the difference between them. EEO counseling is an informal stage of the process, okay? Counselor has set up an appointment with you, have good notes with you, because you need to describe to the counselor whatever harm you have experienced, right? Let's say it's harassment. Let's say it's a denial of some employment opportunity to get a promotion or to go to some training. It's firing, demotion, or retaliation. You complained about harassment or discrimination, and then you were penalized. Tell the counselor everything, because here's the kicker. If you don't raise an issue in the counseling session about something that happened to you, you can't raise that issue afterwards in the formal complaint. So everything else I'm about to say about rights that you have to have said it to the counselor. So just be comprehensive. Okay. The counselor is permitted to try to work out informally your issue, but doesn't have the authority to require a resolution. It's not doing an investigation. Now, you can also do ADR. And ADR is a process of mediation. And the point is you and the person against whom you've raised the concern, sit down, try to resolve it. Now, every agency is supposed to have a mediation program. Some of them are very good, some not so good, but it's only if you want to do ADR that you do it. Okay, so 3, your concern, let's say, has not been resolved through the counselor trying to do anything informally or through ADR, then you will receive from that counselor something called a notice of right to file a formal EEO complaint. Now, once you get that notice, you have 15 calendar days to file this formal EEO complaint. And when you meet with the counselor is going to go through all of this orally. You're going to get something in writing that says it, but please do not miss that 15 calendar days. You can send it electronically. You can send it by mail. All right, once you send it in, step number 4, your agency then either accepts your complaint and starts an investigation, or the agency looks at your complaint and dismisses your complaint. Now, the main reason your complaint would be dismissed is if you're complaining about something that doesn't implicate anti-discrimination laws. Like you complain your manager is a jerk, but they're a jerk to everyone. That's not going to be covered. But if you're complaining about sexual orientation or gender identity discrimination, then your complaint should be accepted and an investigation should begin. Okay, so what happens next? So your formal complaint is accepted. Your agency will investigate those accepted claims. The agency has to complete its investigation within 180 days. That's the expectation. Now, if you've put in that complaint, 180 days have gone by, and you don't have any completion of the investigation, you can do one of 2 things. You can say, I'd like to get a hearing now before an EEOC administrative judge, an AJ, or you can just leave and file your case in court. Okay, so as you will see, you may or may not want to go through the rest of the EEO process. So this is very important. The agency hasn't finished within 180 days. You can just go straight to court at that point. Okay, but step 7, let's say the agency finishes its investigation. Right there on 7. Now you have 2 options, right? You can now request a hearing before an EEOC AJ who will hear your case. Remember, you could have also asked for that if they just haven't finished within 180 days. So you can request a hearing. This is an AJ who's hired by the EEOC. The AJ is going to hear your complaint, listen to responses from the agency, and issue a decision. Now, there are advantages to going to an AJ because even though it takes more time, the AJ can help develop the record. I mean, they're basically part of the investigation. They're more active than a regular judge. Okay, but given where EEOC is doing things right now, questionable, right? Whether it's good to go to an AJ. But you have that option. And then if the AJ rules against you and your agency accepts that AJ decision, yep, nope, no discrimination here, you can appeal that agency order to the EEOC. There's an Office of Federal Operations. You get everything in the order tells you how to appeal. And then if the AJ decision rules in your favor, but your agency rejects that decision in their final order, they have to file an appeal with the EEOC at the same time. So this is where people like Jocelyn and I got involved in this process when we were looking at appeals from administrative judges. So that's if you go the administrative judge route. Now remember, I said there are two options. You can ask for the hearing by the AJ, you get the hearing, you get a decision, goes back to the agency issues a final order. Or you can skip the AJ process completely and you can just ask for a final agency decision as soon as the agency has completed its investigation. Now, if the agency decision is, yes, you were discriminated against, then they'll take care of it. But if the decision is, no, you weren't, then you can appeal to the EEOC. Okay. You have to appeal within 30 days of receiving that FAD. Okay, so you're going to get that final agency decision. If it's against you, you have to file within 30 days. Now, here's the thing. If you win at the EEOC, that's final. Your agency cannot appeal EEOC's decision in court. If you lose at the EEOC, you can still file in court. Okay, so as I said, there's pluses and minuses. The minus is you have much shorter timeframes. So please, if you take anything from this webinar, really take down these timeframes because you have to check that EEO process in order to go to court. Okay, so when can you go to court? Which I think, I mean, I hate that we are in a moment in time where I have to say you should be thinking about when you can exit and file a lawsuit. But here's the thing. So I've said this, but I want to repeat it on a separate slide. You filed a formal complaint, 180 days have gone by, you haven't heard anything, you can exit and go to court. The agency, let's say, finished its investigation, it issued a final agency decision, you're not appealing that decision. Within 90 days after you receive that, you can go to court. Let's assume you did appeal either from an AJ decision or from a final agency decision. If it's been 180 days since you filed with the EEOC, no action has been taken, you can go to court.